Good afternoon, everyone, and a very warm welcome once again to the Logical Talk. As you know, this is the 33rd edition of Logical Talk. It's been 33 months now that we have been running this series successfully. And every month we are coming back to you with some new topic, which is a pressing requirement for the professionals from the community. And as you know, we are back again in this on, with DPDP this time. While we have done some discussions on DPDP in the past as well, but I think this is the high time when we need to bring in more focus, because there are rules which have been notified. There are companies who have you've started implementing the PDP rules. There are policies that are getting changed. We will go in deeper discussion on this. But before I jump onto the agenda for today, I'll just do my customary slide, and I know exactly you are going to tell me what, you will know most of the words which I'm going to say, because that's more of repetition. So Lawrbit is as a leading regulatory technology company in India. We are focusing on providing global regulatory compliance solution, which is we call as GCMS, and I'm sure most of you are users of GCMS. And this GCMS covers regulatory compliances not just for India but for globally. We have done projects in the past, 70 plus countries. Today we are serving around where they say 550. There are right now 600 plus entities which we are serving right now. The slide needs an updation. We have 15,000 plus users and a team of 105 legal and technology professionals who are working behind the scene to provide you these services and keep you updated on the regulatory changes in India and globally. These are some of the list of countries where we have done projects. And apart from GCMS, we are also providing solutions like legal matter management, your enterprise risk management, internal financial controls, and / audit management. And if you need sort of services like regulatory compliance, health checks, audits, those are the also services which we can provide you, which we are providing to our clients right now. With this, let's jump onto the discussion. Okay, now let me quickly start with a quick introduction. And I'm sure many of you would already be, familiar with the faces here. And I wanted to start with the introduction of Ajay. Ajay, thank you so much for joining in today. Ajay is the global head of information security for Sterlite Technologies Limited. He comes with around approximately 25 years of experience, global leadership in information, cybersecurity, and in the technology strategies. He's worked on technology strategies, digital transformation. And you can imagine 25 years experience. And Ajay, I was just thinking 25 years experience. And when we started working on the technology 25 years ago, it was a very, very different version of technology. And today, I would say in 25 years, as you have seen a complete cycle churning from where the technology was then and where it is now. And one interesting thing, he is constantly being awarded, promoted in various organizations, and active speaker. And I'm sure, as is mentioned, you would have been familiar with the face. And public forums, he's also board member of ISACA and a board member for CDPSC Exam Working Committee, International Cyber Threat Task Force, CIO, CXO, and CDSO. And he has, as I mentioned, he's been, he's a good member of ISACA. He's been instrumental in, many discussions as to how the technology, and how the processes should be, built not just for his organization but for the industry as such, setting up industry standards, looking at how the trainings can be provided on the upcoming threats. And one very interesting thing about Ajay, he is also, apart from being a technology professional, he's a lawyer, LLB and LLM both. Very rare combination, Ajay. And I wanted to, I wanted to use this in our introduction. Ajay gave me a tough time when I was just doing a negotiation on our agreement with Sterlite. Because normally when you are discussing a contract with a tech professionals, you know he will not talk on certain things. But it was very interesting and conversation with you, Ajay. So I'm very excited to have you here, and I'm sure with your perspectives, combining law and technology, and how it is now taking a different shape with the DPDPA coming in with globally in different countries. Every they are adopting their data protection regulations. I'm very excited to hear your thoughts.
I wish to add one line here. When I did a first meeting with our gentleman sir, CEO Saab, so we sitting on the virtually. So I ask a simple request, Dada, let me know one thing. Don't need tell me about the law. Let me know how to implement it. How can I ensure it? So our discussion, Pankaj sir, it was almost 2 hours. So then our CEO Saab has realized कि भाई this gentleman has a low background as well. So that was the fantastic meeting, and that meeting is converting the friendship good.
Thank you, sir. So, then I also want to introduce Vikas Bansal. He's a partner with BDO India, and Vikas comes with more than 17 years of experience in IT and data privacy, including 4.5 years of stint in BDO, establishing the IT risk governance
Hmm.
practice. And I remember because I think this practice in when you joined, I think possibly that's when the practice was very nascent in BDO, and you have led this practice to where it what it is right now, an established practice. I remember I used to interact with the person called Love at that point of time, and he thinks that he has moved to Canada after that from video. So yeah, and Vikas has been instrumental in helping a lot of organizations in changing their processes, establishing their processes, policies with respect to the new regulations, DPDPA, and he has a very strong hold in understanding the practical nuances of it. And he's worked in multiple industries. He supported multiple industries. So the very important combination of somebody who can talk on different industries as to why this is important. Because sometimes for our industry, we typically say, okay, मेरे को तो मुझे data protection पे कुछ नहीं करना है, and I'm very safe. But that's when I think because your views will really help us understand how we need to really see this new regulations for different industries and for our own organization per se. So very
Absolutely,
excited
Jan.
to
Thank
hear.
you so much. Look forward.
Okay, so everyone, just as we've been talking on DPDP for some time, and I'm sure all of you would have attended some webinars, some discussions. So while we would run the slides, we would go with a set agenda, but at the same time, we would also try and pick up questions if there are queries which are interesting, and the queries which have come from the users during the registration. We have tried to take few of those queries also in during our discussion today. So my request, if you have a query, please keep putting in the chat box as you always do. And there are interesting queries which we think we need to answer. We will try and pick them also during our discussion. So we want to make it more of a interesting conversation than a one-sided a monologue as a webinar. So what we are going to cover is oversight on the DPDP, more of penalties, and because the penalties are also evolving. It's important to go back and relook at it. Key provisions, regulatory framework, what are the defined important terms, the enforcement stages, the key obligations under DPDP rules, because that's also something which is an evolving area right now. Challenges to organization managing different risk, and way forward for organization. How you need what you need to do right now. And I'm sure some of you have already embarked on the journey, or some of you are still waiting on the sidelines. That yeah, we still have time. And how this journey and exemptions under the act, which is something which at least for the audience we have today, I don't think that's much important, but we'll still try and quickly touch upon them. So Vikas, if you want to
Yeah.
pick it
Thanks.
up
Thanks,
and start
Jan.
from there.
Yeah, thank you so much, Jan, and thank you so much, Ajay, sir, for coming on the board.
and I'm really excited about this. So, I think to start this and to lay the foundation in relation with, though everyone knows about this, I think now, but to understand a complete journey so far, so Digital Personal Data Protection Act 2023 is being enacted on 11th of August 2023, wherein resolution has been passed on into the parliaments, both the side. And after a lot of deliberation, there is a draft rule which has been released in January 2025 for the public consultation. And after a lot of responses which has been received by the Ministry of Information Technology, the entire rule set with their responses has been submitted to the MIST on 7th of March 2025. The MIST has done a lot of deliberation on the same. They have seen multiple practical aspects, and then finally, on 13th of November 2025, they have come up with the draft rules, which basically complementing the DPDP Act 2023 and telling us that what to do in this particular act. This also enable us this also give us and enable us a complete phase out implementation plan, which has been laid down by the ministry, and allow us to give a good time for us to get ourselves ready as an organization from the DPDP Act 2023 perspective. I take this opportunity and the next 3 minutes largely to help you understand what this act actually talking about, what are the pillars of this act. However, there are multiple rule set, multiple clauses within each and every set which we have in place. And of course, we'll take this opportunity to run you past with some of those particular rules and of course the practical nuances and implementation strategies around those particular rules. But just to begin, applicability is something which we all know. So applicability means that this particular act is being applicable to any organization who is storing a personal identifiable information. Okay, I'll take this very 2 minutes that to explain you what exactly the personal identifiable information actually means, because we tend to misinterpret this particular terminology as a PII. Now, the PII actually is a personal identifiable information. I'll take one example. My name is Vikas Bansal, and you are storing my name as a Vikas Bansal with you. Do you think this is a PII information? Yes or no? Actually, it is not. Because if you're only storing my name as a PII, you cannot directly identify me, right? However, let's extend this example. Now you have a Vikas Bansal and you also have my zip postal code. Now you know Vikas Bansal and you have 122001. I stay in Gurgaon. You have my zip postal code. Does this constitute PII information? Actually, no. This is also not a PII information. Both of these information are not PII information, because even having both these information, you cannot directly identify me. However, if suppose you have a address of mine, you have a specific address of mine with my condo number, my house number, my street number, and everything, then all three becomes a PII information. Now, you have the equal responsibility to safeguard my name, safeguard my zip postal code, and safeguard my address in this particular act. So that's how the personal identifiable information come into place, and this is what PII means. Now, from an applicability perspective, any company who is basically storing any particular data of a PII within our environment, this act applies to them, irrespective of their nature and the size of the organization. So there's no threshold which has been defined. It applies to everyone. However, the important aspect to note is that this act means digital. So anything which has been stored digitally in your environment, the act applies to that particular information. But suppose if you are holding a particular information in a piece of a paper, this act does not apply to that particular portion of the world. So anything, so even if you say that I have recorded some information on a piece of paper, then I have scanned it and I put it across in my environment. then yes, the scanned information will be construed as a digital information and the act do apply to you. So that's the applicability from the DPDP Act perspective. One more important aspect, this particular act actually resides within India and outside India. Even for a data principle for which you are processing any particular information in India, you are equally required to protect that particular PI information in the same fashion you are doing it for your own Indian residents. So that's how the applicability has come into force. The second main aspect is the Data Protection Board of India. Likewise, the government has come up with a lot of regulating body. For this particular act, there is a Data Protection Board of India, which will be act as a regulating body in relation with the Digital Person Data Act. And they are in process of formulation and expected to formulate and come very soon. These are the same regulatory body like what we have in RBI or an SEBI or any other kind of a governing body, and they will be ensuring the implementation and the governance on this particular act. Penalties, yes, there are significant penalties which has been put across if in case anything happened or any breach happened or any other deficiency in the obligation which has been put across in this. We will speak little more on the penalty in the ensuing slide. There are some very specific special provisions which has been also covered as per this act, especially, when and in what cases a data fiduciary or the companies which you are having can transfer this particular information outside the country. There are special provisions like for the merger and acquisitions, you are free to basically go and share this particular data. If in case any other specific related amount is there, you can also go and do share this particular data. So there are special provisions. Right and duties, there is a specific right and the duties which has been listed, which has been given to a data principal, which is the individual like you and me. So tomorrow I would like to understand from a particular company that what kind of a data you are processing for me, what kind of a PI information you are storing for me, and what is the purpose of that. You have all the right to check with that particular company. And if in case you think that you wanted to delete, erase, modify that particular information, that adequate right has been provided to a data principal or to an individual whose data has been stored by a particular company. Obligation to the data fiduciary. There are multiple obligations which has been put across to a data fiduciary, which is the companies who are basically storing and processing a particular data. And there is lot of obligation in terms of how and when to collect the data, how to process that particular data, under what circumstance you can process the data, under what circumstance you can transfer the data, and of course where you have to ensure the security of the data. So all that obligation has been put down in this particular act very, very clearly. So these are the few broader aspect or the foundation of this particular act under which each and every element has been formulated. So if we talk about the penalties, so a penalty to an extent of 250 crore rupees has been put across in case of any observing in breach of obligation toward the data fiduciary. However, this has been very specifically categorized under various instances which require to obey by a particular data fiduciary. So obligation toward the data fiduciary 250 crore, any obligation towards the data privacy board and affected data principal toward the notice is 250 crore. Child consent or any data breach toward the children, 250 crore. There is a concept called significant data fiduciary, which has been emanated by this particular law. The significant data fiduciary means that the data fiduciary who are processing a large amount of PI information will be categorized under the significant data fiduciary. However, the notification is still pending that who will become under a significant data fiduciary from the board. But this is expected. Any companies who are processing a large PI information will come into this. And there are some additional obligation towards that. If in case there is any breach in there is a penalty to an extent of 150 crore. There is a very unique concept which has been come up, which is, and this is the very specific if I compare with all the global data privacy law, that there is a penalty toward the data principle has also been put on the table, that if in case there is any observance in terms of breach of the duties of the data principle, then a penalty to an extent of 10,000 rupees can be imposed to a data principle as well. Then, of course, however, any term of the voluntarily undertaking breach will be taken into account, and any other provision of this act minimum is like 50 crore rupees. So that's the extent and that's the risk which we are sitting on today on this particular act. So maybe Ajay sir, you would like to take this up, and I'll pitch in up here.
Yeah, basically, very honest and very transparent to all of you. When we last week I was in Chicago, ISACA headquarters invited me for the new cyber security and privacy framework, and the CDPC was the main concern. So there are the 9 experts who come from the entire globe. The concern is here. I'm telling you what is the DPDP impact come on ISACA headquarters as well. We all know direct and indirect, if we are doing a business in the IT and India is the most report source regarding for the peoples, then what happened? They have realized, they understand key how to handle the situation. So I simply called out, do one thing. Key one thing is the most important. If I'm talking about the DPDP Act, Section 2 and Section 33 is essential. Every legal professional, cybersecurity professional must be understand these things. Then the concern come there, ki how to implement these things in our ecosystem. So one thing is most important, if I'm talking about ki how we identify in our ecosystem, everything is going in the fine. So as you know, if I'm talking about the global organization, any organization, the major concern analysis the traffic of the PI/PHI is a SOAP operation, right? So first and foremost, if you want to implement in properly in your organization, so there is a one program, data security governance program. In data security governance program, first we have to identify in the respective organization has a 5,000 employee. In this 5,000 employee, which channel PI/PHI is staying in the ecosystem. So definitely we develop a data security governance program. In this governance program, we have to take a PI/PHI in from the respective HOD, either marketing, yeah, HR, XYZ. We cannot only trust on the discovery tool. Okay, then first get the PI/PHI information. Then after that, we can ask to marketing team key in your area, in your department, organization, this only PI/PHI from traveling inbound and outbound, because data principle has a 6 rights. Whatever information we sharing here to there, or if some information has leak out, so we have a timeline from the DPDP Act, within a specific time, 20, 48 hours, we have to update to the respective principle. Then here, major concern when traffic in flow from company information asset to outside. So there, two things is the most important. Each and organization generally has a DLP and CASP. Okay. Specific rules, whatever we get from the marketing, HR, XYZ, all the departments, these all the rules we specific define in the DLP. Point number 1. Generally, what happen? Organization putting a DLP in a monitoring mode instead of the blocking mode. Okay. So if they are putting in the monitoring mode, and then next go to the data in transit, it's a CASP. So two things is most important here. When traffic travel to SOAP operation, so here we have to divide proprietary company data and company PI/PHI data. This company PI/PHI data, if the thing is gone to the L1 level, L2 level, L3 level, so we have to specific alert will go to the DPO, data protection officer, so that he will understand what is going on. If normal data, definitely go to the CISO. The reason is that generally we are many times not able to understand what marketing sending outside, what CSR team sending outside. I'll give you one example. Jan sir, there is a one incident and one case happened in the High Court Jaipur. There the one matter come ki one of the gentlemen, citizen, whose mobile is not working the last 72 hours, and he was not aware what is the issue. After that, her daughter was doctor. She came and met to her. So then they realized कि mobile phone is not working. They approached to the Vodafone. Once they approached to the Vodafone, so they are saying कि we don't know what is the issue. Generally, people are replying like this. But suddenly they have realized when went to the HDFC Bank, approx 80 lakh has gone. Then they approach to first HDFC Bank and request to that. They simply reply, in your bank account, we send a 4 OTP. Base of that, this transaction is happened. Then regarding this transaction, amount has detected as per the mobile number and we send a OTP, bank role has been done. Then they approach to Vodafone. Vodafone clearly called out that this thing happen, we issue a duplicate SIM. When the concerned duplicate SIM, so simply asked, show me, where is my sign? But what they realize, that Vodafone outsource entire operation. There is one of the employee, he did the sign, sir, and took the duplicate SIM. And you know very well, sir, if definitely there is a Aadhaar card, then you are doing the sign, definitely come to proper PI. Then what happens, sir? Simply thing, when matter goes to the court, so there is a two party, Vodafone, and second is the HDFC Bank. So when their debate and trial is going on, so just clearly called out only one thing: Vodafone, you are the principal employer. And that time DPDP is not approached, Vikas sir and Janta sir. Only IT Act Section 43A played a big game. They clearly called out, if your ecosystem, any information is leaked, that the principal employer responsibility. Whatever money transaction has been gone, same they have transferred to the gentleman. Vodafone trying to play very well, because as you know very well, big organization, what they did, they will hire the third party and third party is transferred to there. But here just clearly called out, as per due care, due diligence in your ecosystem, if any breach will happen, that is a clearly principal employer responsibility. But now we are happy, DPDP Act has come, government has given a time to us. But one concern here, Janta sir, last week I discussed with my senior in Supreme Court. They asked me one question, Vikas ji and Janji. Suppose myself, my PI has breached. Okay, in the organization, legal head, HR head, CISO, DPO, everybody struggling, putting everything to the government. But what is the benefit to individual person that PI has compromised? So that is the biggest question still in front of the citizen and government as well. Recently, Mr. Our CGI Saab, Suryakant Saab, make a one committee regarding for the AI. So when we put these concerns, so he's making a one committee for DPDP as well, because these concerns are coming. So my concern is here, sir, very honest to all of you. We are working in one organization, so we don't need to think that is a legal head responsibility, that is a HR head responsibility, that is a CIO responsibility, CISO responsibility. No, as a DPO responsibility, because sir, concern is here कि you cannot identify manually, or you cannot pass the ball here to there if anything is happening, कि that is only CISO responsibility or DPO responsibility. Because simple concern, when I went to the headquarters Saka, before that they are taking a 5 information regarding for my PI. This time they took my only 1 information. That information only, this person come, sit in the system, the work on the confidential area. If anything is happen, identification, authentication, authorization, auditing and accountability bind with the respective person. That's it. So major concern is here, sir, if we are talking about to the privacy by design or by deployment. Okay, so all the CISO and DPO work together. In general organization, what happens, CISO, DPO is the same role. But the concern is here, if person do not have a legal background, either they require a good support from legal team, or they have to learn, So major part is coming, if I'm talking about DPD implementation. So DPDP implementation, sir, we have realized approx our 40% support department business support is depend on the third party. If third party ecosystem anything is compromised, and we are not doing a audit, we are not doing a proper due diligence, we are not binding with the contract what is going on the respective person ecosystem, so that is also a big flaw. And here definitely end of the day, if anything is happening, the only principal employee is responsible.
No, no, absolutely, James. So you are absolutely right. And I think this is a very, very important aspect which you have touched upon, that who should be the responsible, who will be taking the responsibility, how this particular act has to go into, and what are the, responsibility towards, and who will be rewarded, or, who will be compensated in case of any breach happen. It's a very, very uh, valid points which you have made up. Absolutely.
And
So
one thing,
what you are saying, there are two things I'm also understanding from here. One is, I have to be responsible, as you mentioned, about my entire ecosystem. So if a training is required, if a confirmation is required, if I have to be careful about the policies, what my employees are signing, the contracts my employees are signing, it's not just about my own employee, but my third party payroll employees also. I need to be sure, because whoever is getting my data, and primarily it works on, it is important for those companies, like anybody who's in a banking sector. I think there was a question from an NBFCs, BFSI sector. If you are dealing with, consumer lending, credit cards, I think this becomes very, very important for you. Second, what you're also saying, it,
Absolutely.
it gives me a thing to say that if for Supreme Court is now thinking, what happens to me if my data is compromised, and I want to get compensated for this. So which means I'm there also. It is somewhere highly getting moving towards the direction where we are saying I'm a consumer also, right? So somewhere of angle of a Consumer Protection Act also is coming. So maybe when tomorrow a case really comes in the court, it will not be only fought in the DPDP, it will also have somewhere, a Consumer Protection Act also, because, I'm somewhere, my part of service have been breached. So, and I'm, responsible for getting the compensation for the breach of services or the product, inefficiency in the product. Very interesting. I think when tomorrow a real case comes in the court.
actually we can answer what happened. Other act help you. I'm not denying, but DPDP Act penalty you will not get. That go to khata in the government. So
Mhm.
that's why all the senior judges and advocate has a concern and request to CGI Saab ki how to do it. And as per process of the India, if any act is coming, bill is coming, to it come to proper protocols. But this concern is very valid. So I hope mid of the March we have one meeting, and let's see what result will come. But all
Yes,
the
I think
senior
it'll be
people are,
already.
yes, sir, all the senior people are accepted the same thing.
Hmm.
Yeah.
I think also it'll be
No,
very interesting to see
I
when. Sorry, Vikas, you're saying something.
no, I think go ahead, please, yeah. I'll come out. Go ahead.
No, I was only making a statement. I said it'll be very interesting to see when the real case comes in this, in the court, of a data breach, because what all sections and what all, other laws which gets attached with this, it'll be interesting to see at that point of time.
No,
And
no,
and
absolutely. See, other laws and other aspect has been very, very important. But I think the beauty about this particular law, and I'm with this time, that this has been put in a very simple language. Okay, and there are very specific which has been put across by the rules as well as by the act as well. Because to the point of Ajay sir, like why and how we are going to share the data outside our organization is a very, very important aspect. And it has been very clearly stated in the act itself that if you are, engaging with the third party vendor, you have to get that particular processing done in a valid contract manner. Okay, so there is a very specific terminology which has been used, which is called valid contract. Now, what is the purpose of this particular contract, which we in our language call data privacy agreement, which is a DPAs? Now, the DPAs has to be very clearly signifies that what is the capacity of that particular third party vendors who are processing that particular data, and what kind of data they are processing and what is the output out of that. But it is also important that, the obligation has to be put down very clearly under the three categories. So will they be a data fiduciary by themselves? So they have to obtain a fresh consent by themselves as a third party. Will they be a joint data fiduciary? Okay, so they will work with me, but they own the data as a data fiduciary and they have to comply with that very specifically. Or will they be a data processor only? So they will be working under a capacity of a data processor, because then the obligation under all these three elements go change and we have to comply in a very specific way. So that's how the thing has been formulated as part of this law. But yes, yes, there are nuances which we need to ensure while executing such kind of a protocol, especially with our third party vendors.
Basically, generally, what happened, Jensen, uh, about the big organization, all the HR head try to transfer the risk to third party. Okay, if they are salary processing, a medical, blah blah blah, it is a group of the data is there. So that's why court is worried. Court is saying ki if anything is happening, they transfer the risk to somewhere. So that's why they put compulsory ki that is a principal employer responsibility if anything is happening. And additionally, sir, how principal employer protect himself? They are going for third party risk management quarterly basis. Okay, if after the due diligence, if find something wrong and principal employer escalate him, update him, or report him, or review him with his management, then definitely third party, according to third party risk management, that respective partner, yeah, vendor, yeah, somewhere, they also responsible. But ultimately, ownership and responsibility will go to only principal employer. That's why what we are doing now, if we are making any contract with our any vendor partner, so we acting and reacting like this is ecosystem is my ecosystem. Whatever policies, procedure, control, anything is there, this should be same on my platform. And sometimes we have realized and that particular ecosystem is very sensitive as per my company policies, as per my classification. We put under radar our SOC operation. Whatever activity is going on, the alert will become here. So we can understand PI, PHA, property data, how is going. So we cannot, organization cannot save ourselves. We don't know anything what is going on there. Otherwise, it is very difficult, Janta sir, to handle the situation. And now the organization, what are they doing? They sometime HR team invited to third party, please come for the passport, Aadhaar card, blah, blah, blah. That is also very risky, sir, now. Because if anything is happening and employee can claim that's happened on my workplace. So here, whatever thing is going on, HR must be take a consent before that doing any activity in the organization, either for the medical test, either for the normal facility provided to the respective citizen and employee.
Yeah, absolutely. And this brings up sorry, Jan, please go ahead.
No, please go on.
So this brings to a very important aspect, which sir has come up with, that what is the difference between a lawful processing and a consent-based processing? Okay, there are two different concepts which this particular law has come up very specifically. So the law basically state very three specific things. One is lawful processing. Second is the legitimate use of that particular processing, and the third is the consent-based processing. Now, taking an example, I'm working for an organization. I am I'm doing and processing a lot of information on behalf of organization, and of course, organization do process my BI information as well. Now, in this case, the general practice which we are adopting is having a privacy notice signed by all the employees while they are being coming on the board. So the privacy notice will cover and tell all the employees the purpose for which this particular data has been taken, how this particular data is being utilized, and of course, how it is being stored and securely within an organization. And it will not be passed on to the third party unless it is required. Now, this is something which is very important as an employee who are already either onboarded or who are joining us. Now, let's take an example before this. If as in a talent acquisition team is going and sourcing some candidates, what to do in that particular case? Do the consent comes into a place? Now, yes, in that's a very tricky situation, because see, a talent acquisition team does source these particular profiles from various platforms in a different capacity, and how this particular information is coming to an organization, how they are approaching to a particular candidate and obtaining a fresh consent to process that particular candidature is something which is a different process altogether, which a organization should implement at a talent acquisition perspective itself. However, once the offer is being rolled out, then of course they can go ahead with the privacy notice perspective. But before that, they have to take a fresh consent, they have to store it, and then of course, very important, retention of that particular data kicks in, that I cannot retain that particular profiles for always in my environment. Okay, that particular profile should be staying with me for a purpose for which it is required. And we have to have an internal policy built up to define such purposes for the retention of this particular data in an environment. So that's how these two things comes into a picture from a legitimate use perspective, lawful processing standpoint of view, and of course, how to bring up the consent mechanism in place.
Because what you mentioned is a very interesting point here, because typically we never bother about asking anybody as how much for how long your data will be kept with us, and specifically at the time of interviews, screening the candidate, your profiles, because and I have also seen, you have now recruitment modules where you are storing data for forever, because you would have somewhere invested time in interviewing that candidate, so there are feedback forms which have been signed by the interviewers. So you want to store it forever, right? And typically it's an enterprise application. By default, we do not allow deletion in enterprise application. Even the deletion is happening, it's only for the virtual deletion. Practically, the data is somewhere still residing in your application, right? So how what is your comment for the IT people, the HR, who are mindlessly storing the data and saying this is going to be with me forever? Because I think somewhere I also see that I have data which is 20-year-old data still lying with me. I don't know why I need the data, but still lying with me. And I think it's not just me. This is a habit for all of us. We don't want to
absolutely
clear the job.
So this is a very interesting point, Jen, which you have bring on. Okay, data retention itself is a very big task as part of this particular act. Now, the data retention basically follows two things up here. One is there are certain PI information which required to be retained by organization, not by DPDP Act, but by different other act. Okay, like IT Act come up, and IT Act say that okay, any information which is required from the tax perspective has to be retained for 7 years. Okay. Now, labor law also comes into place, and they say no, you have to retain any data which is given to me, or any contractual employees are there for an 8 years. And similarly, there are other laws which are requesting from a BFSI perspective. There is a guidelines from the RBI perspective. For the listed companies, there are specific guidelines from the SEBI perspective as well. Now, the interesting borderline message is the Act very explicitly state that from a retention perspective, any other act will supersede DPDP Act from a retention standpoint of view. And we have to retain that particular data from that particular enablement of any other act perspective. It could be IT, RPA, anything. However, that's the first set of the thing. The second set of the thing is that from a retention standpoint of view, suppose it's a marketing data or it's a sales lead. Okay. Now I am collecting a sales lead and I'm storing it and I'm processing it. And I got a consent as well for a user to use my information. But now the point is that how long you can retain that particular data. Now that's something which you have to define as a processing integrity that, okay, this particular data is required for me to process this for 3 years, supposedly. And this is an internal policy of an organization which all organizations have to develop along with a very specific data retention schedule. And then the implementation of that particular retention schedule has to be done to ensure that we are only storing a particular set of data for that stipulated time. However, the Rule 8 has come up now, which has given a very specific guidelines for the certain set of industry in a certain set of manner, like the data fiduciaries are actually required to retain data from the 3 years from the last user interaction or the rule commencement, whichever is. Now, this is the broader guidelines which has been given by this particular act. But within that, there is a categorization which has been put across from an e-commerce perspective, a 2 crore registration, online gaming intermediary, social media intermediary. These are the guidelines which has been put across by the act. But in nutshell, a data retention schedule has to be maintained to maintain any of this information, but you cannot store any of the information forever. That's the.
And I used to add just a few things. Kamal sir explained very well. Last year, there's a big debate happened with Mr. Dugal and Mr. Rai, and we are discussing about this thing only. Mala sir, act has come, rule are waiting. Okay. Still, how much time data retention will be in the organization is big concern. So there what happened, the ball is moving here to there. So what they are thinking, yeah, we cannot see citizen for only DPDP. We have to see the Company Act also, Labor Act, Labor Law also, because we have to see if somebody person did any white collar crime, yeah, anything in the industry, and we require for scrutiny purpose. So definitely, if I'm talking about the local police or CBI, so they wish to investigate something. So how can they do it? So that's why sir is right कि जो supersede करता है that should be go for at least 5 to 7 years before that. But now rule it is very clearly indicate कि how much data is required. If I'm talking about to the our organization, to very honest with you, we also stuck in these all the things. But जनता से भी थोड़ा सा कानून पड़ा है. So what we smartly mention in the info cyber security policy that information asset provided by the organization for official purpose only. Personal data is not allowed. You keep and save here. Regarding for your personal data, if you require anything, so HR function will support to you. So Janta sir, what happened? Before that, people are working on 10 years, 15 years. So they have a habit. They making a only one system for official and personal purpose. When they're leaving the organization, so that is a very biggest challenge because they're asking, we got MD approval, we got this. So then after that, I put a one process, EDT, external data transfer process. In this external data transfer process, I make the column and template that mention only for the business. Personal purpose, I didn't give anyone and put myself in the final approval. So then what happened? I know that if you wish to improve the things and comply the thing in regarding for these all the things, so then definitely we have to think about low perspective as well. And additionally, now DPDP Act has come. Board understand the things properly. If anything happen, to 250 ka penalty will be come. So, but in the organizational point of view, we have to first of all discovery properly, either manually, automatically, where data is reside. Okay. Then there is a simple concern when matter is started, Janta sir. So just ask you only one question: data rest in transit encrypted or not? So we have to ensure that Whatever data is reside PI, PHI, it must be encrypted, point number one. Point number two, if data in transit, to definitely, if any cache bit tool is required. Point number three, most important, sir, what happens? Sometimes the matter is going to court and we invite to employee, you have this. So if his lawyer is smart, तो क्या देता है? Simply, sir, I don't know, I didn't get a training. How can I do it? So now that's why we mandate for each and every employee, he get the training. After that, he give the exam. Exam like a CSSP, he get at least 70% marks. But now we are going for little advance. Whenever user complete the training, that must be digitally signed. Because digitally signed signature is accepted in the court, nobody can deny it. He passed the credential here to there. Second thing, sir, most important and very critical, what happen when we hire any big four for the forensic investigation in our organization. There are two things is the most important that we keep in our mind. Point number one, whenever analysis a forensic person will do, so we have to ensure that we have given our own information asset as a secondary. Primary employee, fine. And whatever he has to do, that must be under surveillance of CCTV, because employee can claim. If you are doing, and additionally, we have to bind in our contract as well. If anything is required to present to the court, then any big four person will become who did the investigation and present everything to the court. Otherwise, it is very difficult and it is written and reverse back to only organization. So these are the point essential. And additionally, if we are developing any application at containing the PI, PHI, so it must be first and foremost, suppose we have a secure SDLC SOP. So Pankaj ji and Janta ji, now what we have done, we put our privacy concern there. Whenever the analysis is going on, it should be masking, it should be encrypted, and those person manage the things, he will be entire responsible. If the application will go in public or private cloud, yeah, somewhere, yeah, some instance out of India, whatever. So we have to take assurance for that person that all the data reside in India only, and accessing, controlling, maintaining with the proper IAAA, so that if anything will happen on the respective information of the respective employee, so we have a respective logs to present to the concerned person. PI, PHI log must be traced, must be bind with the SOC environment, so that if anything happen, to chain of evidence we can present. Jen sir, over to you.
That's interesting discussion. Let's also move next, because I think we have limited time now.
So now, from the enforcement standpoint of view, so now the rule has come up with a very specific guidelines in terms of enforcement. So of course, from the board has to be established from an immediate effect, and then of course the law is being regulated from an immediate respect. The first kind of trigger for every one of us is that there is a requirement of the consent manager registration, which required to be done with the Board of India, which required to do on or before November 2023. However, board is awaited, so we are looking forward to have a better clarity on how to register and when to register. But yes, that's the first schedule. And the second, effective May 2027, which is 13th May 2027, all other rules will be applicable, and of course the entire enforcement of this particular law will come into place. Just a week back, there are certain clarification which has been provided by the Ministry of Information Technology, where they would like to prepone some of the timelines, though this has not been come very specifically in a formal channel. But yes, there are certain timelines in relation with retention and the erasure to be commenced 3 months down the line. And from a significant data fiduciary perspective, commencement of the data privacy impact assessment and of course data audit has to be started on an immediate effect. Identification and the specific data security provision has to be done on an immediate basis. And lawful processing of data should come into an immediate effect. This is something which has been just proposed a week back, but we are still awaiting the clarification. But yes, nonetheless, all these particular rules will be enforced on or before 13th May 2027, and everyone is required to be ready by that particular timeline. Next,
So,
please.
Vikas, I'm just I'm repeatedly trying to repeat this. You said preponing. There are talks of preponing.
Yes, there are talks
Okay.
of preponing the timeline. So now, instead of giving 18 months, they are like for the for the eraser and the retention, they would like to implement just in next 3 months instead. Okay, so the
Okay.
compliance
So,
in relation with eraser or the retention has to be implemented in the next 3 months.
okay.
So that's how they are thinking as of now.
So what you're necessarily saying is, somewhere, the time, the clock is ticking right now. So we have,
Yes, yes,
we have, because 3 months is when you have to put such kind of a processes, because it's saying retention and erasure sounds very easy, but in the IT world today, when you're keeping 100 copies of your data, saying I'm erasing it and really erasing it, it's not that easy. You have to
that's
really possibly buy some tools, making capital investment, repeat investments, to maintain those tools also. That something has to be incorporated, right?
Yeah,
Okay.
absolutely, because it's a long procedure. So no organization can comply in a month or a two. It's a long process. I will try and cover that as well. But yeah, no, this is a 12 months process in large.
It will take more than 12 months because
Yeah.
it's a big thing.
Yeah.
Ecosystem is not small. There is a lot of channel data can go outside.
Yeah.
Right. And these are enterprise decisions. It's not
Yes,
an
yes,
individual
yes.
decision, because enterprise
Agree.
decision has its own
Agree.
timelines, right? Before we move, we just want to pick up one question. Biometric data, it includes KYC, including photograph of employees. They're all comes under the Act, under DPDP, right? So
Yeah,
my
absolutely.
organization is
In fact, these are being categorized as a a sensitive personal data information, and even there is a law as of now, which is IT Act 2000. Within the IT Act 2000, there is a IT Rule 2011, which actually specifically talk about the sensitive personal information. So yes, this act
And
applies to
when
that.
the biometric and KYC data reside there, it must be essential, must be encrypted in rest in transit as well.
okay.
That safeguard
On
is
a lighter
essential.
side, on a lighter side, we typically buy, those biometric machines on a three-code basis and try and implement the one which is the cheapest one. That's a typical organization, because when you specifically have seen the branch
Agree.
setup where you have multiple. So
Because it's
what
sensitive.
is what?
Please continue.
So yeah, so I'm saying is, what is your suggestion for the organization typically which has a large branch setup? Because if here's the single office, an ITS comes set up, you have one office and one multiple floors, but it's still easy to maintain. But in a branch setup, when every branch you have multiple.
I'll tell you one thing, sir.
uh,
Suppose if you are a small organization and at least you have a Windows server, a Windows system. Okay, sir. So
hmm,
they have a inbuilt CA service, certificate authority service. Okay. Then window administrator, what will do? He will export the 10 to 15 user. Their data is there, 100 users. Okay. And issue the certificate through the CA service. Okay. So this certificate, then a system is work as a certificate authority server. As a we are getting a digital signature from outside. Okay. Here, what we have to do, we have to give a little bit training to our IT Windows servers administrators how to configure a CA. So same thing they will do it. Whatever enterprise organizer we are getting for RSA or Zscaler, the same thing will do it.
Understood. But I was also talking about, large setup where you have 1,000 branches. Maybe not the same service provider is providing you biometrics and all those branches. I mean, you may not have a centralized data server there. Uh, what is have
Then
you
then
seen?
then there is option, sir. So we have to go in decentralized mode. Okay. Then what we have to do, first we identify ki I have 100 data. In 100 is a 20 data belong to PIPHI. So there we have to create a one standalone Windows server, enable the CA service and put data is there. When authentication will not go direct to the main server, it go to the CA server only. So then in this scenario, you are the safe. Mota concern, sir, Jan sir, if a small organization cannot afford more security control, so Windows Linux has an inbuilt lot of security services. Here we have to major focus on certificate authority service. So let's see example of small laboratory is there, medical hospital is there. They are not able to put high investment. So they can take a Windows server, put all the data there and issue a certificate to respective user. Whenever user will be login, only he is able to access the data. If any breach will happen, as a due diligence, we can show it. We have a Windows server with the certificate authority service. We individually distribute the key. Here we will use a asymmetric algorithm. Public key different, private key different, sir. So no sharing there. So there we can protect our same as enterprise is doing the same.
Understood. And just want to take one question, from the audience before we move next. So specifically, this question has come around your third party or service providers, maybe your manpower service providers. Do we need to, while you are trying to bind them in contracts, but do you also need to get an audit done?
It is mandatory, sir. I'll give you a live example. Last year, I took my one background verification partner. So I was shocked, sir. So when I did a meeting with the CEO, he was saying, Mr. Abdullah, you are not authorized to audit my because you didn't mention in the contract. So now it is very essential. Every quarterly, we have to the audit of the ecosystem and anything. Most important thing is here, CERT India sending a advisory to all the CISO. Then we have to must bind in our contract as well. Whatever advisory will issue by the CERT India, this should be must be comply by the partner and this send a compliance report. It seems that your ecosystem, their ecosystem, if there is any vulnerability, it is a fix. If vulnerability is open, there's a data travel here, so it seems that it can exploit easily. And dark web is a very big example, sir. Whenever we will see that some organization doing such kind of things, in future we will see significant data fiduciary will be the biggest risk because they're containing more PIPHI data. So that's why it is essential. Partners ecosystem is also our ecosystem. And one mistake generally people are doing whenever they open their ecosystem and our ecosystem between the firewall ports, to versa. So we have to ensure that we only allow the ports. Let's see example, I'll give you FTP 21. We not mention on 21. We change the port name like a 95, 96. So probably people will not understand. So I mean to say that when two ecosystem will integrate it, we have to ensure that both the ecosystem integrate the respective service. It is not vulnerable and only limited access, limited port allowed to the respective person. And these rules, whatever we creating between an ecosystem, we have integrated our SOC environment. If anything go up and down, immediately we get the alerts.
Understood.
So I think largely in the interest of time, Jayant, we have covered it in our discussion, but anything specific which you would like us to highlight, we can definitely do it.
Anything specifically you want to talk about significant data fiduciary, what are their responsibilities, what I can expect from them?
Yeah. So as I told, significant data fiduciary is basically the data fiduciary who will be, catering the large PII information or processing the large PII information. The additional obligation of the significant data fiduciaries are as follows. The first and the foremost, they have to appoint a data protection officer. So there is a consent manager and there is a data protection officer. Now, the consent manager is being required to be appointed by all the data fiduciary irrespective. However, for the significant data fiduciary, it is also required to appoint a data protection officer as well. And it is a person who will be kind of, supervising the entire data privacy office for that particular organization. The second obligation is to basically have the annual data audit to be done, annual independent data audit to be done for the significant data fiduciary. The third obligation, which is to perform an annual data protection impact assessment for all their application and the critical systems on an annual basis, and this is also required to be submitted to the Data Privacy Board of India. These particular reports are required to be submitted to the Board of India. And then, of course, these are the few specific additional obligation which are required to be catered from a significant data federation.
Understood.
I wish to
So,
add,
Ajay, you want to add something?
yeah. Two things is the most important. Sigismund Data Fiduciary has a DPO as well and concerned manager as well. But as we know, in our enterprise environment, ecosystem is big. There is a lot of channels. Okay, take the data from the systems. If we wish to save and protect ourselves, so then it is mandatory and essential. We have to stringent our SOC operation. We have to define data for different for property data and different for the PI, PHI. If any, let's see one example, sir. Then, sir, in our organization, what we do, if any one person sending a data that belong to the confidence sensitive, so immediately SOC team our generate a alert to respective users and is HOD. Generally, you see, sir, oh, sir, by default, I send this mail, by default, this mail is attached XYZ, blah, 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 blah. Then I realized if any matter will go to the court, I am accountable, responsible because I'm the CISO of the organization. Then I simple put one thing, I enforce COT, confirmation of truth. When an employee sending a such kind of data, so his HOD and employee themselves, what is the thought in the going on that time mind? He has to return. And HOD has the sign. And that COT we put in HR his personal file. So what happened then, sir? Because after enforcing this process, what I have realized, my 78% true positive has reduced. So that is very essential if we wish to control automatically regarding the digital data. So such kind of process and thing we have to enforce, then definitely you can control.
That's interesting. I think this is what you are trying to say is that somewhere you're making people conscious about their choice, because today you don't ask me why am I doing why to me I want everything, but the moment you tell me to be specific about why I need this, maybe I might actually not need it. Sometimes I might say, okay, fine, I can do without it. Somewhere, again, the word privilege.
And what happens, sir, when the team will come for independent audit yearly, they will ask a specific question to you. Your incident is increasing. What action you are taking? It seems that control are not implemented, yeah, awareness is not properly. So if such kind of things we will do, so definitely we can prove and we can show in court as well. That is the due diligence we are following internally.
Right. Great, sir. I think just a quick question about to everyone. We have 3 important slides right now coming up. We're going to talk about the industry's important challenges and how you need to prepare. Now let's get on to till here we spoke about the basics about the regulations. What are the key discussions happening, challenges, some practical insights about from the experiences of both Ajay and Vikas. Now let's move on to the challenges to organization you're managing regulatory, operational or reputational risk. So because
there are two kind of challenges. Of course, one is the external challenges, second is the internal challenges. The external challenges are very, very clear. Like, there are still some ambiguities in terms of the interpretation and, of course, evolving of this particular rule, which is being all done by the ministry as well. We are anticipating, considering the large population base of India, there would be a misuse and the dummy exercise of the data principal rights. So we are eliminating those dummy exercise and ensuring that this particular data principal actually wants something change is something which we need to think through, and how we exercise those particular rights. High volume of grievances. It is expected that a lot of people, because coming up with a lot of grievances in terms of the data retention, data processing, and management of the sum. And the last in the not least, which we have discussed, is data going outside organization to our vendors, to our third party, and how we align the compliance. So these are some external challenges, which are somewhat controllable, some are not controllable. Then, of course, there are internal challenges to an organization. The first and the foremost is low awareness. People don't know about this particular requirement, limited understanding of the DPDP requirements. Resource constraint. Internally, company does not have the right people, right budget, expertization to implement the same. Organizational change management, because it is important and imperative to note that this particular change will touch upon each and every function of your organization, which include your operations, to a sales, to a legal, to an HR, to a compliance, to any other, IT as well. So how to manage that particular entire change management is something which we need to fix. New technological investment, of course, consent management tool is one of the investment, but in and around from a data security standpoint of view, from a retention standpoint of view, from a classification standpoint of view, from a DLP standpoint of view, from a SIM standpoint of view, all these are technological enhancement and of course require a good amount of investment. Complexities, especially in the consent and the notice management, then from specifically from the unique identifier and how to basically go and interact with that particular unique identifier. And one more important aspect is data discovery, that how we will get the data into a particular environment while, ensuring that, we execute any particular right or storing the same. So these are the few challenge, but the action plan as below. The first important thing which we have to do is to position data protection as a strategic business priority. Okay, it cannot be done by just a kind of a small item in the tick in the box. It's a complete strategic business priority. Get your maturity assessment done. Understand where you stand as of now in relation with this particular data. Get your data inventory, kind of laid down. Get the entire record of processing activities to be documented. Then drive very specifically technology and process enhancement. Update your policies, update your procedures, get your consent build up, get your notices build up, get the entire information technology in place to accommodate all these kind of relevant things. So this is something which someone should come as an action plan mitigating these particular challenges.
Then, sir, I wish to add few points. Vikas sir explained very well. When I enforce that in my organization, first and foremost, privacy policy integrate with the cybersecurity policy. Point number two, if any incident happen, because everything digitalized here only, so that should be integrated with the incident management process of the SOC environment. Point number three, if individually, let's see, generally we are saying least access to employee need to know only. Here we are putting least access to admin need to know only. Segregation of duty, separation of the duty, and additional most important point, we have to consider such kind of information that PIPHI is there. Either we have to digital signature, yeah, two-factor authentication is essential, because if any breach will happen, identification, authentication, authorization, accountability clearly mention the chain of the logs, chain of the incidents. So these are the things, if we bind properly, sir, so we will not face any issue in front of the judiciary, in front of the board, anyone.
So now cyber, that there's now an interesting thing we have so far been talking about. We we started our IT journey as there was something called CIO, CTO, then CISO came in. Now we have a DPO coming in. So how you are envisaging this in the organization? There are, there are going to be different roles in organization. There is a DPO, there is a CISO, there is a CIOs,
Basically, sir,
or
at
because
least
you're somewhere talking about, these policies to merge together, but they come under different heads in the organization.
agree,
Sounds
sir.
easy.
I'll find a solution. Basically, if I'm generally talking about to IT, so one principle CIA, confidentiality, integrity, and availability. If I'm talking about to the OT, it reverse availability, integrity, and confidentiality. But here what happen, you are right, कि CIO, CTO, okay, these people major focus on availability part. If any operation will down, so definitely internal impact only. But now, as per law of land, DPDP has come, and if any citizen confidentiality compromise, okay, base of the law of land fear factors, organization now understood what is the meaning of the role of DPO. Okay, so now what the organization is doing, CISO and DPO is the same person almost in the organization. Okay, but you have a significant data fiduciary, then DPO has a different role, CISO has a different role. CISO focus on security part, DPO focus on the PIPHA security part. Okay, but now you have to see CIO and CTO, this role most majorly convert in CDO only, Chief Digital Officer. Okay, so slowly thing is rounding here to there. Okay, because this DPO role definitely, and very honest with you, nobody wish to carry. Only technically, legally expert person has to carry. Before the answer, you see that ki sometime CFO is IT head. CFO has a CIO role because only money transaction is there only. Okay. So now situation has been changed, sir.
Because what's your opinion? What's your experience in the industry? Who's the DPO?
See, it's a combination actually of the four specific departments, I will tell you, because now the data privacy office has to operate separately. It cannot be integrated into a particular function. It's a function by itself. But now the organization are strategically basically placing it up, supported by four key functions, which is largely coming up from the CISO office, the legal head, HR function, and the CRO office, which is the Chief Risk Office, compliance side of the world. These are four are basically, forming a bridge and putting up this particular office as in a place supported by.
And who does that DPO reports to typically in the organization?
The DPO requires to report to board directly.
Like not even CEO?
No.
No,
Okay.
no. The reason
They
is
can
that
report to a CEO as well, but it is being recommended to be reporting to the board.
because
Okay.
he is an independent authority. Okay, if anything is happening, he directly report to board, and additionally in board, independent director as well, part of the board. They have invested the money in the organization. They also have authority to see what is going on. The transparency is most important here.
I'm realizing actually 1 hour is too small for this topic. Oh, that's comes interesting part. I think because there have been some questions around, whether, we are a medical equipment service provider or we are a BFSI. Uh, Tell us how its impact is it applicable on us. So maybe in one statement I want to ask you is, does it impact everyone or it is only impacting some industries?
I think it impact all the industry irrespective, and it's sector agnostic, because this applies to everyone, and everyone has to comply in accordance with the DPDP Act. Of course, in the lieu of the processing activity which they are doing.
Uh, so every industry it applies every size also.
Yes,
I mean,
even you are a smallest company with a turnover of maybe ₹1,00,000 does apply. And if you are a very large company, it does apply. So it's not size constraint at all.
Sir, it seems that na citizen has a 1 to 100 a 1,000. If compromise, then compromise. That's why it is
and
essential. Yes, please. Yes,
that,
please.
and essentially what this also says in terms of penalties, they are talking these penalties in terms of the absolute number. If I say compare it with GDPR, the GDPR somewhere says percentage of your
That's
revenue, and I was saying is I
4%,
have a one.
4%. Yeah.
I said my revenue is only for 1 lakh rupees, and because I said so I'll give you 4,000 rupees and get done with this. But here, the penalties could run into crores even if my turnover is 1 lakh rupee. Okay. Yeah, because
absolutely.
so because you want to pick this one.
Yes. See, from a manufacturing and industrial perspective, it's important to understand uh, who are our large, PI information bases. Our large information, from the manufacturing and industrial setup, The largest will be our employees. Okay. And the second largest, or maybe over and above, is our contractual or the contracted employees who are working in the factory premises. Okay. Now that is something which is the largest PI information. Of course, the vendor do come into place. The vendors are equally responsible. The customer PI information are equally responsible. But here, the biggest risk comes into this place, and the management of the same, especially the contractual employee side of the world, because as Ajay also mentioned, that principal obligation comes with the data, data fidelity only and the company itself. So that's the size and the threat which we are talking about from the manufacturing perspective. From the BFSI and the fintech, the gamut of the kind of threats are very, very large, because BFSI is first of all processing a very large number of PI information, not only from an processing of the information perspective, also from the collection of information for the multiple compliance side of the world as well, which include the KYC information, which include multiple other technology based information, the facial recognition data, the biometric, and so on and so forth. So of course the gamut is very large. The management and storing and of course appropriate measure has to be in a different size and the constraint. So that's how it is. Healthcare is again a very different ball game altogether, because from a healthcare perspective, the data does not only include the financial data, but a health information, which is a PHI data, right? Now, how the PHI data has a more significance, because it's very attributable to a particular persona, and how to manage it, what kind of a consent, and what are the touch point of these particular healthcare information to be stored and put together. What are the restrictions from the access standpoint of view has to be put across, is also something which we need to put across. Now, retail again, a very high volume based data, because you have a PO's point of contact in place. You are dealing with the direct customers and customers, and they are very curious that how you are taking my information, where you are utilizing it, what are the multiple promotion activities which has been done, and how it is being done. So all these things has to be catered in a very, very specific manner. And IT SaaS providers are dealing the data in a very different way, because here the data is not belong to that company itself, but in fact there are a lot of customers' data, and customers' data principal data is being put across in that particular platform. So all these industry are dealing with the data in a different size and nature, and each and every company has a different way to handle this data. It cannot be saying that, okay, whatever control I'm implementing from a healthcare perspective can fit into a retail or a BFSI. It will be very different from the control standpoint of view. However, the nature and the processing, documenting that particular processing is very, very important up here, that what exactly I'm doing with that particular PI.
Just one quick question. There are a lot of service B2B service providers who may typically not be using technology, but they still process user, for example, a payroll service provider, or compliance service provider. They may not use technology at times. It's all a paperwork. Do they also fall into ambit?
Yes, of
But
course.
Data is getting exchanged. Data is getting exchanged on emails.
Data is being exchanged on the email. Forget about email. Even if it is a platform which is being processing any particular data on behalf of customers, okay, they're equally liable. The only thing which they not need to do is to take a consent specifically from that particular data, because they are just processing that particular data. But other obligation in terms of data security, data processing in that particular way, not reaching out to that customer directly for any particular purpose, is all come under that radar, and they have to comply with that particular information or that particular data which is coming up from the customer in the capacity of a data processor. However, for a company like that, they must be having their own employees, they must be having their vendors. All that comes into radar, and then of course they become a data fiduciary in that capacity.
Jantaji, I wish to add one thing. Let's see. if any partner, yeah, any vendor, yeah, any organization we wish to do business together, first and foremost, we have a approx 250 points checklist. We have to say that. In this checklist, it will focus on process, people, and technology. If we found that they have a technology, they have an email system without email gateway security. Whenever any email inbound in any ecosystem, so it has to check the 7 flags like phishing, spam, blah blah blah. If we do not have such kind of things, so then what we do? We will simple recommend if you was to connect with us, so this gateway is required. Point number two, if I'm talking about to the endpoint security, suppose if we are exchanging data with him and he send me some attachment with the ransomware attack, yeah, he sent me the some CNC connection attack. So sir, how can I save my ecosystem first? So first and foremost, he has to accomplish these 250 technical points. If we feel that key thing is okay, then we are going for big to be business. If we feel that he is not able to do it, so then we are putting him in our DMZ zone. We have to put there least access with the least control.
Understood. Sir, one more question, Ajay. You are typically from a, you know, from an industry which where you not don't have much of a personal information from your customer's perspective, right? But because that's typically where we see the DPDP talking about, but there are other sides. How easy it was for you to convince your internal stakeholders, and what are typical pushbacks and questions which you get um, uh, from in a company like yours, which is
Uh, so there is two type the concern. Suppose I know that here is a risk. Okay. So if I know here is the risk, that's why in my organization putting my approval in the last. Okay, I have authority. If board or MD saying, "Ki no, you have to accept." I simply say, no, bhaiya, I have to report cert India, I have to report to SEBI, I have to report to cert US, now DPDP as well. If anything will happen, definitely I go to jail. So here, organization give me authority in the as a last approval. Okay, if anything is not comply with the compliance a business requirement and organization put a higher risk, so I can reject it. But point number two, if you feel that here there is a less risk, yeah, something, so we take a risk exception approval from the board because
okay.
I am engineer of the management. Either approve or give me risk exception approval. That's it.
Understood.
But here is my duty. I have to explain to board, I explain to management with the proper due diligence. If anything is happening, the people ask you why the people hired to you. So then I show either approved or risk exception.
Okay, Vikas, you want to come here?
Yeah, thanks. I think we did mention this about in our enforcement side of the world that, what we have to do. So immediate actions are that first and foremost is start creating your map, creating your data inventory maps, understand where your data is being origin, how it is being flowing into a complete environment, and then of course where it is being put into rest. That's the first exercise which an organization should start doing it. The second is, of course, start, doing a complete training sessions within an organization. Start understanding the process integrity part of the same. Start understanding the lawful processing of the same. What we have done, and we have taken this as a best practices from a GDPR standpoint of view, we are starting creating record of processing activities as a complete data, which is called ROPA. And this will help you document your data inventory, help you understand your legitimate use of interest, help establish the responsible organization department and the function and the post flowing the data information to the different side of the world. So get it done. Get the basic security in place from an encryption standpoint of view, at least on the data in the rest. Get the basic security from the transit standpoint of view. Get few very specific. I have seen a lot of organization having a DLP, but the DLP is not being imposed to a PI information. It is all imposed only from the confidential or business critical information standpoint of view. So at least get that extended to the PI information as well. Fix your privacy policy, fix your privacy notice, get the draft standard clauses in relation with the data privacy agreement as well. Um, Start assessing your vendors who you have given an outsourcing work, understand what they are doing, how they are doing, what is the big data which is being going outflow. Pro Prepare a complete step-by-step guide in terms of what all people you have to basically trigger, what all process integrities or data which is being going to a different channel, to a different service provider for any different processing activity. And then you should have a complete roadmap in front of you, giving a priority from an implementation standpoint of view. So these are something which you have to do on an immediate basis as we are the clock is running, and we don't have much time to implement all these activities. Uh, Till November 2026, you should get your entire assessment done, implementation done, get your independent audit also done. Have a complete algorithm in place from a retention standpoint of view, from a schedule standpoint of view, and of course, start monitoring everything. And before May 2027, ensure that you have the right technologies and the tool in place. They are up and running. You start creating the consent. You start, sending the notices for the right use, and of course, it is being done. So these are the way forward for us as an organization. However, from a significant data fiduciary perspective, get a data protection officer appointed. You can also outsource a data protection office as well. There is a provision of that. Get the independent data audit done. Get the DPIA assessment done, and then of course start monitoring that on an annual basis. So that's what the kind of way forward which we have for all the organization starting today.
Thank you so much, Vikas. I think this is quite helpful. I know that we've already, we've already overran by 3 minutes now. Ajay, with your last comment, I think we would come to a close. And Vikas, just want one last question. If anybody wants to reach out to you, we can share your email ID with everyone, or for everyone, if you want to reach out to Vikas. Vikas, now,
Yeah,
do I
yeah.
have your explicit do I have your explicit permission to share your PR?
Yes.
Yes, absolutely, Jeff. Absolutely.
So,
Otherwise, Vikas sir put a section 6.
so
No, it is being
so
recorded, I believe.
So, we'll share Vikas, the coordinates, if details, if you want to reach out to him, or you can reach out to your account manager or from a CS team if you are already using GCMS. They can help you connect with Vikas and the team, and you can take the discussion forward from there. So thanks so much, Vikas, and I understand you have to run for another call. Ajay, one last comment, and then I think we'll come to a
I request to everyone, please keep in the mind whenever, because I have faced a lot of incident from FBI, CBI. Okay, so because I was a simple and techie guy, but after that मेरे को कानून पढ़ना पड़ा, right? Two things is most important, very honest to all of you. If any incident will happen, so board easily pull and push from your side. You have to handle, you have to manage. Point number one, you have to thoroughly ensure that key section 33, section 2, section 6, 8, 10, or 11, these are rigorously enforced with your all the SOP, standard policy and guidelines. Point number two, if you are giving the awareness to employee that it is mandatory, either take a sign or take a digitally sign. Point number three, very critical and very essential. Please guide to your SOC team proprietary and PIPHI data. They must be segregated properly, and in your organization, data security governance program must be properly enforced. And you take PIPHI information confirmation of the respective department of the departments. And point number four, very essential. That's we got a lot of benefit. If any incident will be happen, to you must be put the COT confirmation of truth. Point number seven, data at rest, data in transit must be encrypted. And last but not least, you have to set monthly governance call, your management, and quarterly based with the board. Whatever thing is there, you have to properly present. And if you feel that key in the lower side people are not listening, so make somebody accountable and responsible. Otherwise, if anything is happened, so you are the responsible. DPO and consent manager role was confused before rule, but now it is clear. But significant data fiduciary must be ensure that data reside from any channel, it must be encrypted. That is the first and last question was asked by in the court regarding for your due diligence point. Before that, only section 43A safe to us, but now DPDP Act come with the full flash. That's it, Sarjan sir.
Thank you so much, Aditi. I think I think I'm going to specifically share this one last minute of your discussion on a separate video or a short, because this is very important. This kind of a crux for what people have to focus on, and maybe because your last discussion, pointer on the slide, we are going to have two different videos pushed onto our YouTube for people to view it separately. Now, thank you so much, and I really appreciate the kind of insights which came in today. And I also know that 1 hour, 1.5 hours is not enough for this topic. So for everyone, I think the clock is running. We don't have much time in our hands to really start putting in things in place. I don't think government is given time us to think now. Government is given time us to take action, because it's enterprise, it's IT. It requires every function and involvement. It needs a lot of information. Even while collating how much of a data where all the data is residing, the list of your application, the list of places where your data, PI is residing. I think that itself is a very, 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 very big task. Specifically when I talk about the, some key industries like BFSI industries and all. I think we start taking actions. Need any help, please feel free to reach out to Vikas. Thank you so much, Ajay. Once again, thank you so much, Vikas. Have a good day, and thank you, everyone.
Thank you so
Thank
much.
you.